Good morning, and welcome to another exciting episode of Webinar Wednesday. On behalf of the entire team here at Employers Group, I really wish to thank you for joining us, and I want to let you know how much everyone here at Employers Group truly appreciates your participation in our webinars. It does mean a lot to us to share this time with you and these always valuable discussion points. Today, we're going to be focusing on everyone's favorite topic, employee handbooks. My hunch is that we all share the same sentiment that if we could find a way to somehow get back all the time we've invested into all the minutia and the endless details and finer points of every handbook policy we've ever had to deal with, our lives would be so much brighter. But it's the nature of our existence that we are tasked with the monumental responsibility of ensuring that our organization's handbook is truly a guideline for our employees rather than a goldmine for plaintiffs' attorneys. And obviously, because there's no such thing as a quick chat about handbooks, as you can imagine, we have a lot to cover today. So we're going to power through this as efficiently as possible. As always, we do welcome your questions, your comments, your suggestions. If you'll notice on the bottom right side of your screen, there should be an area where you can type these in. And we will do our very best to get to as many of these questions as possible, but we expect we'll have to get back to a few of you on some of the questions because there is so much to go over. And at the end of the program, we'll also provide the SHRM and the HRCI recertification credit information. And certainly not to bury the lead here, but I do have the honor and the privilege to introduce our presenter today, Mr. Mark Nelson. No doubt a familiar name and a familiar voice for most of you, and an extraordinarily respected and revered advisor for all of our members. Mark is a senior consultant here at Employers Group. He's advised, I would imagine by this point, thousands of employers on every facet of employment compliance, practical guidance, best practices. He travels the nation delivering a range of training programs. He facilitates our SHRM prep course and so much more. And I can't say enough about what a pleasure it is for me personally to get to interact with Mark on a regular basis. And Mark has been the architect of much of our philosophy on employee handbooks, which is why it's particularly exciting to be able to have him here today to lead our program. So with that, I will turn it over now to Mr. Mark Nelson.
Thanks, Bill. I appreciate it. I'm not deserving of that introduction, but I'll take it. Just before we get it going into today's discussion, and as Bill said, we have quite a bit of information to get through today. We have to, of course, place conditions on the scope of our discussion today. In other words, of course, as we're talking about the disclaimer, please know that a determination of the best course of action for you to take with your own employee handbook and drafting it, rolling it out to your employees, etc., involves discussions that are much more detailed than what we could provide you in today's guidelines. And please don't construe any of our pointers as rendering advice, legal or otherwise, in any particular case. And of course, we are not trying to provide you a comprehensive discussion of your employee handbooks today. But with that, now we can move on. Just to give you kind of a sense of where we'll be going today, we have our agenda. If we can move to the next slide. Today's agenda would be to address first and foremost kind of the philosophy we take with regard to employee handbooks and the considerations that everyone should take into account when they're looking at drafting an employee handbook or even making a decision whether or not they want to have an employee handbook. That is necessarily always involving a discussion of employment at will, and additionally how handbooks can touch on implied contract concerns. Recently, there's been, in the last several years, there's been a lot of activity on the forefront of the National Labor Relations Act, specifically the board making a few decisions that implicate employee handbooks. So no discussion of employee handbooks is complete without touching on that as well. We can kind of close out the initial thoughts on our philosophy when it comes to drafting employee handbooks, and then we'll dive into some actual sample policies or selected policies, I should say, before closing it back out with a summary of our discussion and then some handbook pointers that Bill will actually be offering. And then, of course, for those of you who would like recertification credits, we'll have that as well. In California, there is no specific law or regulation requiring employee handbooks. That said, if you are considering having one, there are certainly some established norms regarding what you really must include in an employee handbook, and we'll talk about what those are. An example, of course, would be an EEO statement. You would absolutely want to roll that into your employee handbook if you were deciding that you were going to have a handbook. Despite the absence of law or any sort of legal requirement necessarily, like a labor code provision that mandates employee handbooks, they are a common practice. And you may, through your EPLI, Employment Practices Liability Insurance, or other insurance, it may be actually required or certainly encouraged that you have employee handbooks. There are certainly arguments for employee handbooks. They put employees on notice of their most significant responsibilities, so everyone's on the same page, and you can reference back to the employee handbook and hold employees accountable for having read it. Additionally, they can be retention tools by promoting your benefits. Those of you with attractive employee benefits packages, this is a great place for you to roll them all into one document. Certainly, employees can refer to handbooks instead of contacting HR for every minor question that they might have about their eligibility for a leave, perhaps, or how we calculate overtime, or anything that is more procedural, but certainly impacting their employment relationship in a significant way. And then, of course, they promote uniform or consistent treatment with uniform policies. So you're taking away concerns about employment discrimination when we know everyone is supposed to be behaving in a certain vein. And as Bill actually intimated in the introduction, well-drafted ones certainly deter plaintiffs' attorneys and goes without saying. There are some arguments against having employee handbooks, and some employers have chosen not to have them. That would be some concerns that if you did have a more flexible approach to your human resources policies and procedures, uniform practices that you declare in the employee handbook certainly commit you to following them, which may not be part of your culture. Handbooks can be updated as laws change, which of course in California is very frequently, usually literally every year. Handbook language can also compromise at will and give rise to implied contract claims. Usually, I should say, poorly drafted employee handbooks can do that, even well-drafted ones as well. And then handbook shortcomings may signal more interest from a plaintiff's attorney to dive a little bit deeper into their client's concerns. So without, not to deter you from employee handbooks, but those have to be acknowledged. With regard to employee handbooks, some employers have considered going the way of alternatives to employee handbooks altogether by promulgating policies and procedures as freestanding documents. You can choose to present packets of information with individual policies to your employees, and as you develop new policies, roll them out into individual written policies that you circulate amongst your employees, and then of course develop a means by which you communicate those to employees, usually or typically in all employee meetings, and increasingly communicated via online to your staff. Some employers have foregone the notion of employee handbooks as communicating policy and will revert to or supplement with express contracts of employment, meaning written contracts of employment. You can still negotiate an at-will or include at-will for your employees, but we're still not seeing that as a prevailing trend. It's more an outlier of an approach to establishing norms and procedures for your employees. Really, employment contracts seem to be reserved for your C-level staff and IT professionals, where it's difficult or it would be difficult for the company to lose those employees. There are certainly problems with express contracts. Generally speaking, when an employee is alleging breach of contract, if there is a contract that exists, all they have to do is march down to a court of law. By contrast, however, if an employee is alleging a violation of statute like Title VII of the Civil Rights Act or the Fair Employment and Housing Act, they must do what we call exhaust the administrative remedies first. In other words, they have to go to the state agency or the federal agency that enforces that law, give that agency an opportunity to investigate. Sometimes they can get a right to sue letter and then with their plaintiff's attorney march into a court of law. But generally speaking, it's better if you don't have that immediate claim of breach of contract, so that there's an automatic entree for the plaintiff to seek remedy in a court. Of course, with all of this, however, these are strategies that you should be having an open dialogue with your legal counsel about. We are certainly not in a position to advise you on your particular strategy with regard to this. We just merely want to point out kind of what our philosophy is or what's underlying it. There are certainly some problems here, and with that, I'm going to actually pass this on to Bill to kind of share with you the all too common problems that we've found.
Thanks, Mark. Yeah, we have the, I guess you would say, the privilege, and I'll put that in quotation marks, of looking at dozens and dozens of handbooks every year and doing reviews of them and advising on the handbooks. And we can definitely say that we have never yet seen the perfect handbook. If we had seen it, we would capture it and we would share it with everybody. And when that day comes, we'll make sure everybody's aware of it. We see a lot of very common problems, though, with handbooks, and that's what we wanted to be sure to point out to you. And you'll probably see yourselves in some of these, and as you look at your handbook and the condition it's in right now, see if any of this sounds familiar. Very, very common is the history book, where it's capturing stuff from a bygone era. And it has not been updated in many, many years. And of course, this creates tremendous liabilities. And as Mark's kind of alluded to, these are guidelines and these are conditions that you want your employees to be following. And if they're not the ones you're actually following anymore, you're not going to have a lot of validity should there be any kind of a claim or an issue. The other thing we see a lot is the novel, where everything that the organization is involved in is included in the handbook. It's much, much too long. Nobody's going to read it. And you want your employees to read this. You want them to understand what's in there. You want them to know what's in there. Similarly, the kitchen sink, where everything gets thrown in, including the kitchen sink sometimes. You've got policies that don't impact the employees one bit. We've got policies that really are just addressing procedural issues, where you put the keys after you open the supply closet. This does not have to be in an employee handbook. Keep the employee handbook limited to the issues that actually impact the employment relationship. The jigsaw puzzles, we see a lot of handbooks that are still missing essential policies. We see this a lot. I'll tell you the number one policy that we still see missing a lot is social media. Another one we don't see a lot, and this obviously in California and a few other states is really critical, is lactation accommodation. So there's a lot of things, and actually one of the policies that we see missing a lot, and Mark I think is going to talk a little bit about this too, is the salary basis for exempt employees. Really, really critical policies that sometimes are not included. Then we've also got what we call the whack-a-mole, which is where you're fixing one problem and creating another. So things just keep popping up. Be really careful when addressing issues like performance management and promotions and internal transfers and how that might affect your at will. That's the most obvious. But be really, really careful, because so much of one policy connects with other policies. And that's a theme that we're going to come back to in a minute too. The other one we see a lot, the technical journals. These are oftentimes written by attorneys, which is not a bad way to have your handbook written, but it becomes a technical journal that nobody's going to understand. Think about your employees when you're putting your handbook together. What are they going to understand? What are they going to be able to follow? What's going to make sense to them? What will they pay attention to? But The other thing is these fantasy creative writing exercises. There was a time a few years ago we thought this was kind of fun, and we almost started to think, gee, maybe this is okay. I'll tell you, the more we look at these, it's so hard to be creative and funny and humorous and to have a theme in your handbook. Where this becomes a real problem is when you create a handbook and you're based around a theme that the company is working on right now. It might be something with your current philosophy, your marketing strategy, however you want to present yourself. 5 years from now, you're not doing that anymore, but your handbook is still showing that. So unfortunately, while we love the idea of being creative and amusing, we're finding that just sticking to the guidelines, sticking to the facts is a safer way to go. Our all-time favorite, though, and this is the one we see a lot, is what we now refer to as the Mr. Potato Head. And this is handbooks where you can tell they've been cobbled together through different sources. You call up one source and you say, hey, do you have a sample policy of this? You call Employers Group, you get a great sample policy on something else, and you cobble this thing together and you get different tones. Sometimes it's in third person, sometimes in second person, sometimes it's very detailed, other times it's very brief. We see this every day. It's not going to be as effective a handbook, and the bigger threat on this is that it's very easy to have redundant policies where you're stating the same thing over and over again, and worse than that is policies that contradict each other. So a handbook really needs to be a cohesive piece of literature when it's put together. So we'll talk a little bit more about ways to avoid these types of issues, but these are the things that we see most often as we look at your handbooks. Now, thank you, Mark, for letting me jump in on that. I'm going to turn it back over to you now.
Thanks so much. So any discussion regarding an employee handbook implicates employment at will concerns. I'm sure many of you on the call are familiar with it, but let me give you kind of a 2-second introduction to employment at will if you're not familiar with it. It's the presumption of the employment relationship in every state here in the Union except Montana. And with regard to employment at will, it basically stands for the proposition that as we've structured the employment relationship in the United States, it's evolved into this rule that you can end an employment relationship at either party, by the way, the employer or the employee, without notice or cause. In other words, the easiest way to capture that with additional explanation would be that you can terminate an employee for a good reason, a bad reason, or even no reason at all, but never an illegal reason. And please note, the presumption of at will is actually a rebuttable presumption, which an employee can overcome with additional information. A little bit of history here for you, just because it's relevant for our discussion today. It arose out of the 19th century with a legal scholar who his scholarship is now actually deemed a little bit suspect. And through the early 40s and 50s, judges, I should say, were being confronted with fact patterns that made it very obvious that the employment at will doctrine as an absolute was an untenable one and unjust. It resulted in unjust outcomes. Of course, remember, this is before we had Title VII of the Civil Rights Act of 1964, which prevented individuals from sexual harassment, etc. In the course of a very short period of time, at least in American jurisprudence perspectives, we started to carve out exceptions to employment at will. Public policy exception, obviously beyond the scope of what we can talk about, nor is it really necessarily relevant to what we're talking about today. But the one that is particularly relevant is the implied contract exception, which arose from a case called Toussaint v. Blue Cross and Blue Shield. Any employment law law student knows this case very well. It was basically built on this promise that there was a company that had a supervisor who was promising employees the world. Essentially, you'll have a job as long as you want one. You're a permanent employee, which we no longer say, by the way, regular full-time, not permanent. Nobody ever leaves the company unless they choose to leave. As of course you could imagine, given the fact pattern, the company then laid off one of those employees who was given that very promise, which the judge basically said, you can't make these promises in a vacuum. Let's move on and talk about how that's relevant to the analysis. Implied-in-fact contracts are in contrast to an express contract. And express contracts can be written or it can be verbal, but the terms of the agreement are clearly communicated between the parties. By contrast, an implied contract is where the actions of the individuals clearly communicate that they understood there to be a contract. Generally speaking, express contracts override implied contracts, but implied contracts can result from a number of different circumstances that we'll talk about in just a second. Please note handbooks can be found to constitute implied contracts, especially in California. Courts analyze implied-in-fact contracts based on the totality of the circumstances. So personnel policies and practices would be one consideration, employees' longevity of service assurances and actions by supervisor, and of course, industry practices. Disclaimers are also viewed through the same totality lens. I bring this up not to state that they are definitively in contracts. This is a conversation that you and your attorney should be having regarding how you strategize. Generally speaking, the goal of employment or the goal of employers is to preserve the at-will relationship, and how you and your counsel choose to do so is up to, of course, a conversation, a privileged conversation that you and your counsel have. But we do want to bring this issue up so that you're aware that there are some significant implications to drafting an employee handbook. Some suspect actions, which of course relate back in many cases to that Toussaint case I just mentioned. When supervisors, or when you permit your supervisors to make these assurances, we never fire employees absent just cause. As long as you have your job, as long as you do your job, I won't fire you, and everybody stays here forever. After your first year of employment, you will also get X, Y, and Z. Those can, under certain circumstances, imply a contract of employment for a year. Referring to individuals, by the way, you want to say after the first year of employment, employees in this position will be eligible for, but never reference the individual specifically. Referring to individuals as permanent employees as opposed to regular or full or part-time employees, that's a big no-no. And then, of course, promising very rigid step disciplinary procedures. That's what unions contract with companies to afford their bargaining unit employees. But generally speaking, it's not in an employer's best interest to have a rigid step disciplinary procedure unless it's a concession as part of a negotiation for a collective bargaining agreement. In other contracts in employee handbooks, here's an issue that we occasionally encounter, which is that employers want employees to commit to things like non-disclosure agreements or arbitration agreements, but then they roll it into an employee handbook, which we generally don't want to constitute an express contract. Obviously, that creates some conflict. So generally speaking, if you want employees to be bound to terms that would survive the employment relationship and therefore requires that you have a contract, you want that to be a freestanding document and not rolled into the employee handbook, which would then, of course, compromise the rest of the employee handbook, or could. And of course, obviously, this is all done in concert with your counsel. We certainly recommend that all contracts be reviewed by your legal counsel and other critical documents, which we'll talk about here in a moment. Freestanding policies, even if you don't intend your policies to apply after discharge, employees can argue that they weren't aware of policies that were buried in the text. Bill mentioned earlier essentially the novel where the company chooses to throw everything in an employee handbook. We certainly recommend keep them as short as possible so that employees can't argue things like invasion of privacy claims that are implicated by inspection and search policies, or drug and alcohol testing policies. The more critical your policies, the more you want employees to actually sign a freestanding policy as well. we're seeing a trend with regard to what those policies actually are these days. Meal and rest periods, salary administration periods, or salary administration policies for exempt employees, and certainly a drug testing policy we would recommend be a freestanding document, even if it's in your employee handbook. And certainly we would want it to be in the handbook, but have the employee sign a separate policy outside of the handbook as well. Like we said earlier, in the discussing the agenda, no conversation about employee handbooks is complete without also referencing the National Labor Relations Act. Even if you're non-union, when we generally think of the National Labor Relations Act, we think of collective bargaining and unions and that employment dynamic. However, there is Section 7 of the National Labor Relations Act, which implicates all non-supervisory employees' rights to engage in concerted activities for mutual aid and protection, regardless of their union affiliation. With that in mind, the board has found in the past that there can be handbook policies that impact Section 7 rights. On June 6th of 2018, so just this month, in fact, the board clarified that it will be shifting focus, essentially, to how it approaches enforcement of those Section 7 rights. And in so doing, they basically articulated three categories of how or three categories that provide escalating levels of concern with regard to violations of Section 7. This actually comes from a Boeing decision the Boeing decision from last December, which you may have heard about as well if you're up on NLRB decisions. But in this memorandum that they published in early June, they basically broke out their enforcement of Section 7 rights into three different categories. Category 1 would be the most employer-friendly category, and that would be policies in employee handbooks that are generally deemed to be lawful because they don't interfere with Section 7 rights, or the employer's interests generally outweigh any employee rights. Category 2 would be kind of a case-by-case analysis by the regional offices to determine whether or not there are Section 7 violations, because it's not quite clear whether employee rights are actually impacted or if the business justifications outweigh those employee rights. So they'll look at those with a fine-tooth comb. And then finally, Category 3 actually is a scenario where it directly impacts Section 7 rights, and there are, generally speaking, no justifications that would outweigh the employee rights under the Act. We do have some examples of each one of those categories that they were willing to provide. By the way, the National Labor Relations Board is really big on examples that illustrate policy. So if you're writing a policy that has implications under Section 7 of the National Labor Relations Act, you should be thinking about whether or not you can include examples for your employees that illustrate your points. But Category 1 would be things like civility standards or no photography or recording. Additional policies would include prohibitions on insubordination or disruption of work, confidentiality, defamation, misrepresentation, intellectual property policies. And then this one's important: restrictions on speaking to the media on behalf of the employer, because in the very next category, they say that restrictions on speaking to the media generally may violate Section 7. But if you're doing it as if you're the spokesperson for your employer, that would be a Category 1. Category 2 would be just a blanket prohibition against speaking to the media. Category 2, remember, this is the category where we look at things on a case-by-case basis. These would, what could be a problem, according to the National Labor Relations Board, would be a too broadly worded conflict of interest policy or a too broadly worded confidentiality policy. Additionally, there could be concerns when it comes to disparaging the employer or using the employer's name. We mentioned speaking to the media, off-duty conduct that might harm the employer, and then rules against false or inaccurate statements versus clearly defamatory statements. Those could be concerns according to the National Labor Relations Board. And then finally, the confidentiality of wages, benefits, and working conditions. If you're telling employees they can't talk about their wages, hopefully none of you are doing that. That can have Section 7 implications, in addition to California prohibitions as well. And then finally, moving on here, I should say, restrictions on membership in outside organizations, and then voting directives or prohibitions, telling employees how they have to vote in elections. Obviously, that's goes without saying. Here's our philosophy, I guess, if we can offer it up for you, is always have employment law counsel review your employee handbooks before publication. As you can see from the slides that we've just covered regarding implied-in-fact contracts or National Labor Relations Board implications or National Labor Relations Act implications, there are a lot of minefields when it comes to employee handbooks, and you don't want to be setting those off. Avoid unnecessary indicia of contract, even if you're advised that the handbook, if you and your counsel agree that it's going to be deemed an employee handbook, still you don't want to be overly complex and get into technical journals like Bill mentioned earlier. And then, of course, because of the implied contract issues, they should be no longer than necessary. And also, employees just simply don't read employee handbooks that are, an inch thick. And additionally, it makes it easier for employees to argue, you're holding me responsible for page number, 55 in a 100-page booklet. I can't remember that much. And then generally speaking, our recommendation is to avoid things that we see a lot of HR departments that want to roll all their HR policies and procedures into an employee handbook, but most of those are only relevant for internal HR policies and practices. They're not relevant to the employment or the workforce at large. This is not a place for you to have all of your HR policies and procedures located because of all the concerns that we've just been addressing. Move that into a separate HR policies and procedures manual if you want to have a document like that, but the employee handbook should really be limited to those critical policies. When it comes to those of you who operate in multiple states, there are certainly additional considerations that you have to take into account. Do I want to publish one handbook in all 50 states, or not? Hopefully not all 50, or if maybe 49, exclude Montana from that consideration, or do I want to publish multiple employee handbooks in those states? We generally recommend that you take into consideration these factors. How much interaction do the various offices have when one office finds out that other offices have an entirely different employee handbook and the benefits are not nearly as good as the benefits in headquarters or something, then that can cause engagement issues. What is the additional cost? Obviously, employee handbooks are no cheap venture to engage in, and especially if you're having legal counsel review them. And then how different are the laws in the various states? If you're operating on the coasts and in the upper Midwest, those policies, those states tend to be in alignment with regard to employee protections. The South and Southeast tend to be a little bit more employer-friend oriented. But if you have operations in all of those states, it may be a little bit more complicated. And Montana really is kind of an outlier when it comes to how we look at employment law. They have a number of considerations that complicate issues. So if you're operating in Montana, it'd be best that you consult employment counsel in Montana first under any circumstance. Here is a sample table of contents. This reflects the sample that we usually generate. Generally speaking, we like to open with an introduction. Some can call it a disclaimer, if you will, then move into the governing principles of employment. It's critical that at the very beginning of your employee handbook, the most important policies are delineated there, so employees don't have to flip through pages to the very end of the document to find, say, their EEO or harassment prevention policy, or the at-will language, or the open door. And then after that, we recommend moving on to something like operational policies, employee benefits, leaves of absence, general standards of conduct. Other than the first two, and then of course the final acknowledgement of receipt, you can be a little bit more flexible, but we would certainly recommend governing principles of employment be at the top of any employee handbook. The disclaimer introduction, please, this is one of those policies that you want reviewed by your employment counsel definitively. Disclaimers can complicate at-will arguments by also disclaiming agreements of at-will. So you want to be very careful how that's crafted. And then the NLRB has in the past, though it's not clear whether they still harbor this, still have this belief, but that limiting changes to employment at will to only written agreements between the employer representative like the CEO and the employee in a written document, that's the only change of at will that is permitted, since of course employees can successfully negotiate just cause terms if they choose to elect a representative and have a union on their premises. Employment at will, again, this is a critical policy that be reviewed by your counsel. Don't assume your employees know what at will is. You always want to state at will, talk about that either party can end it for a good reason or without notice or cause, but then also talk about the fact that it means that the employment relationship can end for a good reason, bad reason, or no reason at all. And as always, be mindful of implied contract issues when it comes to at-will status. Another policy that we deem critical is the open door policy. You want employees to know that at any given time, there are avenues open to them, multiple avenues open to them, be it their immediate supervisor, another supervisor, human resources, or even the CEO of the company if it's important enough that they can voice any work-related concerns. We don't want to foreclose them or allow them an argument that they really could approach no one, i.e., the only people they could go to would be the government agency. Be sure your complaint procedures afford that flexibility as well, by the way, with regard to your open door policy. You want to communicate your willingness to hear concerns by your employees. Another critical policy that we want to see, we generally like to see at the beginning of any employment handbook, is the EEO statement. Obviously, employment discrimination claims continue and they can be very expensive. So it's always in your best interest to have an EEO statement that's clearly articulated at the beginning of your employee handbook that lists all the protected classes that are currently mentioned, rather than some sort of blanket. Some employers I've seen where they'll list the protected classes under Title VII and then any other protected class by state law. Or state or municipal law for that matter. Generally speaking, if you know what the company is committed to protecting, even if it's beyond, say, the scope of what the states wherein you operate would require, we recommend commit to that in writing so that it's very clear that that employee reading that know that they enjoy protections specifically delineated for them. Moving on. Attendant to an EEO policy would, of course, be a harassment prevention policy, which again addresses that you don't permit harassment on the basis of those protected classes. You also need to include a specific discussion about sexual harassment. There are some standards there, like letting employees know that the company does not require the condition that an individual be attracted to someone for it to constitute harassing conduct. That, we know that to be a power issue between the two individuals, and so we prohibit it on the basis of that. We also prohibit it on the basis of the perception that someone's in a protected class, the basis that an employee is associated with someone in a protected class. All of those considerations should be rolled into your harassment prevention policy. Those of you in California, there are some very particular things that you have to include in your policy. In addition, we also recommend that you engage in a disability accommodation issue. This is a topic that's gained a lot of steam in recent years. It used to be believed that there was not a lot of legs, at least nationally, for the Americans with Disabilities Act because it was so hard for employees to prove their status as disabled. And that's no longer the case. It's getting a lot more play, and as such, you want to invite employees to engage in the interactive process and clarify how that be done. And in California, of course, include medical conditions as well. With regard to workplace violence, of course, that has become an essential policy in recent years, and certainly something we would like to see up at the top of your employee handbook. You always want employees if they see something, say something, just like the directive from TSA. Make sure that they're reporting any sorts of concerns that they might have. And then you might also consider addressing abusive conduct and how to handle it. There are some complications with that, so run that through your legal counsel. I will leave it at, I will bookmark it at that unless somebody has questions at the end of today's presentation. Drugs and alcohol, another essential policy. We certainly want employers to include at the beginning if that's something that they are going to include. Also because, of course, we want to make sure that they're reading this policy of all the policies. I would probably also have a freestanding policy for drug and alcohol testing if I were to do that, but certainly prohibiting employees from being under the influence is a policy worth promulgating. With regard to that, there of course would be a carve out for prescription drugs, but only if they don't impair the employee's ability to perform the essential functions of their job. And then with employees, and certainly here in California, we recommend include language that allows employees who are seeking treatment for dependency issues to be given an opportunity to do so. This is just a classic. We're now moving on to operational considerations. This is just a classic policy that you generally see when it comes to any employee handbook, and that's the employee classification section. It's important that, of course, employees understand how they are classified as individuals, whether they're exempt or non-exempt, meaning they are exempt from overtime and paid a fixed salary basis, or if they are non-exempt from overtime and paid an hourly wage and entitled to overtime for daily and weekly overtime daily overtime in states that require it. We also, of course, want to address their status as a regular full-time or part-time employee, meaning some full-time employees get more benefits like group health participation than part-time employees, although this can vary from employer to employer, but defining what their status is based on typically how many hours they work, and then what benefits they are eligible for or excluded from. And certainly those of you who have temporary employees, including them as well. And generally speaking, we only see that temp employees typically are eligible for benefits mandated by law and perhaps not anything else. But that's where we're certainly employee classification section is critical to your handbook. Overtime, of course, another critical policy from an operational policies perspective. You want to define what that 7-day work week is for purposes of weekly overtime, midnight to midnight, Sunday to Saturday, or Monday to Sunday, whatever you define that work week to be. Of course, you can define it to be whatever you want, be it noon to noon, Tuesday noon to Tuesday noon, the following noon. And you can even have different weekly overtime calculations or weekly 7-day cycles for different shifts within a 24-hour operation, so that people don't always have to start their shift on one work week and end it in the next. You want to state that you pay employees all overtime. Never, we see this still occasionally, that you will not pay out unauthorized overtime. That's just simply a violation of the law, so don't do that. And state that only hours actually work count towards overtime. You don't have to count vacation and holidays and gifted time towards overtime calculations unless it's been your past practice or you state otherwise. So we generally recommend don't state otherwise. And then, of course, for multi-state employers, be careful for qualifying who is eligible for daily overtime and or premium pay that you can get in here in California, like the 7-day premium that you get for working the all 7 days in the defined work week. This is a policy that we don't see enough of. And basically it stems from the Department of Labor recognized that back when employees were bringing claims, exempt employees were bringing claims for violations of the salary basis regulations, which address how you pay out your fixed salary to your employees, that employees were losing the entire exemption because of these cases being drawn. And the Department of Labor wanted to essentially give employers an option to implement a policy to kind of head off at the pass these employee claims that their salaries weren't being administered fairly. So if you add a salary administration policy, then the employer can essentially avoid these loss of exemption classifications. What that means is essentially you have a safe harbor and you're instructing employees to bring concerns about how their salaries as exempt employees were administered and whether they were administered correctly to the company so that the company can explain. They did articulate considerations that you need to take into account, that the company will investigate immediately, and then the company would prohibit retaliation for bringing these concerns to the company's attention. And then we also recommend that you have language in there that a high-level executive is available if you have any secondary concerns, so that there's never an avenue closed to the employee to seek relief for the salary administration. The consequences of not having it in can be much more deleterious. With regard to meal and rest periods, that's a policy that's an essential policy these days as well. Certainly, we would recommend including that in your operational policies. You want to define when non-exempt employees are expected to take their meal and rest periods. Certainly here in California, refer to or they should refer to their supervisors for any concerns that they might have. Breaks may not be combined, nor may they be taken at the beginning or end of the shift. That's not permitted. Although a lot of employees would like it to be that way, this is not one of those situations where employees have the luxury to dictate to us how and when they want to take their meal and rest periods, as we well know here in California. You can address that smoking is limited to meal and rest periods if that's a concern for you or your employees. And then it should be a violation of company policy not to take the meal and rest periods as required in your meal and rest period policy. This is another freestanding policy that we also see employees sign off on, just like the previous policy with regard to salary administration for your exempt employees. Exempt employees would get the salary administration freestanding policy to sign off on, in addition to signing the acknowledgement of the handbook, and your non-exempt employees would see a meal and rest period policy separate that they would also sign on in addition to the acknowledgement of receipt of the employee handbook. This is a new development, but it's kind of largely flown under the radar. If you have employees who take a break, because that break is paid, if you have employees, all employees would take a rest break. But because that rest break is paid, it used to be the position that a lot of employers took, that the employees could be essentially required to remain on company premises. It's paid time if we're controlling or directing their work, and since it's paid, employers took the position that we could direct them. The DLSC has recently clarified that you have to allow employees to leave premises if they so choose during their break. Pay periods, state the days of the month and or week that employees are expected to be paid. This is essential for your policy, even though employees obviously know when they're paid. Clarify how and when the employer will pay if a payday falls on a weekend or a holiday. And generally speaking, do not require direct deposit. It's certainly not permissible in California. You cannot force employees into direct deposit. You can certainly encourage a practice, and many states follow suit with that as well. Personnel records, California changed the law on this in 2013, and we're still seeing that employers have the old rule in their employee handbooks. We now know that employees or their representatives are entitled to not just copies of things they signed, but also the entire personnel file. And former employees may be restricted to requesting the copies for no more frequently than once a year. You want to prepare, in addition to the employee handbook policy on this particular topic, a form that employees would submit to make a written request for their personnel file. Insurance benefits, remember, consult your benefits provider. You want to define who is eligible for group benefits and include a disclaimer that if there are discrepancies between the policy language in your employee handbook and the plan documents, obviously the plan documents control. Vacation, certainly this is state specific, so this is a very big conversation for you to have if you have multi-state operations and you want one uniform vacation policy. Certainly in California, use it or lose it policies are not permissible, but you can cap the accrual at a reasonable rate. In California, unused accrued vacation must be paid out in termination. Many states have that requirement as well, though some states allow you to condition it, but if you don't, then it must be paid out. Point being, these are all conversations to have in great detail. The law of vacation policies varies greatly from state to state. Sick leave, paid sick leave, again, this is a policy that's got a lot of employers scratching their heads, because even here in California, if you operate in multiple cities, you're looking at upwards of 7 or 8 policies that could theoretically apply in California alone. If you have those considerations, certainly you want to be aware of what each municipality in each state requires by way of paid sick leave. This is a very developing area, and certainly would require, like the vacation policy, a great deal of consideration if you're going to have one uniform paid sick leave policy that applies across the board. Family and medical leave, this is important for those of you employers who have more than 50 employees total. You want to make sure that you have a FMLA policy. We did change the law to include military, family, and caregiver leaves. Make sure that that's been rolled into your policy. We're still seeing a few occasions where that's not the case. Another development that kind of flew under the radar is that you cannot mandate the use of vacation or sick leave if an employee is drawing a disability benefit plan. So you want that language that says if you are eligible for like SDI or PFL, SDI being state disability insurance here in California, or paid family leave, which is to care for a family member here in California, or if you have a private short-term disability benefit that you're entitled to collect, the company will not require the use of vacation or sick leave for you. If you're interested in Googling, you can Google the Title 29 of the Code of Federal Regulations, Section 825.300A3. That's what that stands for. The 29 CFR is the citation for Title 29 of the Code of Federal Regulations at that section, if you want to look in more detail. Pregnancy disability leave is a hot topic here in California. Obviously, this is a state law. So those of you with multi-state operations want to determine whether or not you're going to allow individuals access to this benefit. They may have their own benefits that they're entitled to in the particular state wherein they reside. Usually speaking, it's the employees. Employees are afforded protections in the state where they reside and where they perform their work. Generally speaking, that's a broad statement, though. Your policy, you want to make sure that it's been updated not to reflect 16 weeks, which was the old calculation, but now 17 and a third week. Employees are entitled to 4 months off, and the state determined that 16 weeks was kind of shorthanding those employees if you were to state it in weekly terms. So now that has been adjusted to reflect 17 and a third weeks. We're still seeing some handbooks that don't have the correct calculation there. Ensure your employees are entitled to healthcare continuation for the duration of PDL. This was another change or development. It used to be that if you had PDL policy here in California that you did not need to require that employees continue group health participation. That is now mandated. And then you want to also commit to reasonable accommodations. We've always kind of believed that that was an obligation that employers shouldered, but it was clarified recently that that is in fact the case. So you want to reference reasonable accommodations for your disabled employees due to pregnancy. Military leave, USER is a very expansive law and can entitle employees to be protected, to have job protection up to 5 years. You want to probably, in most cases, unless you work around military complexes and have a lot of employees who are in the military who serve you or in the National Guard or Reserves, keep it relatively short. It's a very detailed law and beyond the scope of what probably most of your employees would reference, but certainly it's not a bad idea to reference that you are aware of military leave for your employees. Bereavement leave, this is not required. I'm actually not aware of any states that currently require it, though don't hold me to that. But there may be other implications that trigger protected leaves, like employees who are having difficulty grieving the loss of a loved one, requiring FMLA for their own serious health condition. And certainly, if you have a list of people who would qualify for bereavement leave, you want to be sensitive to issues that might trigger protected classes, like for sexual orientation. We still have registered domestic partnerships here in California, even with the advent of gay marriage. So you want to be sensitive to that issue. Also, with concern for protected classes, if you allow employees to grieve the loss of a grandparent, you may have older workers, and unfortunately, regrettably, there may be circumstances where your employees may need leave time to grieve the loss of a grandchild. So you want to include all those categories to be sensitive. And then with bereavement leave generally, obviously, these are very important life events for individuals, bringing someone into the world or saying goodbye to someone. And you want to be very sensitive to the concerns that employees would have, just as you would want that afforded you. Prohibited conduct, with regard to kind of standards of conduct, we're now moving on to section 5 of our sample table of contents. There are some different ways to approach this. Some folks list a laundry list of all the prohibited conduct. Others argue against that, saying that, well, you can't possibly account for every variable that might exist, and if it's not on your list, it's easier for the person to argue that this was not something anyone contemplated could ever be committed by anyone, so it was not something my client should have ever been fired for. That being said, the trend we're seeing is towards that laundry list. Certainly, you want to reinforce that at will is still in play with your prohibited conduct policy, and if you reference step discipline, keep it open-ended. Punctuality and attendance, certainly this is an important policy for any employee handbook. You want a procedure for individuals to speak to their employees before before their shift is to start, except in, of course, in emergencies. Require them to delay or to relay the expected duration of their absence, so we know how long they'll be out. And then, generally speaking, this is a conversation, of course, with your counsel, but having it be an essential function of everyone's job. Clarify that absences burden coworkers so that they understand that there's a reason why. Dress code, that's a hot topic for a lot of our workplaces. Certainly, you want to reserve the right to decide the appropriate attire, and then have the ability to tell employees to go home and change before they continue work. Employees should commit to making reasonable accommodations on the basis of religious dress and grooming practices. There are 2 protected classes that require reasonable accommodations: religious and disability. And in this particular context, for religious accommodations, many individuals may request accommodations to a dress code policy so that they can dress consistent with exercising their faith. Certainly, with regard to those jurisdictions, and more generally speaking, where gender identity and expression are protected, you want to be cognizant of allowing those individuals to dress consistent with their gender identity and expression. So making affirmative statements like that for both religious dress and gender identity are important. Health and safety, certainly you want to relay a strong commitment to employees' health and safety, require that employees report dangerous conditions, even if they're already abated. That's important. We want to know if there are any hotspots where there might be other problems arising, and also, of course, with any health and safety policy, you want to reiterate workers' compensation considerations by having them report any work-related injuries, however minor. Driving on company businesses, this is a new policy that we've seen a lot lately, and I have not talked to anyone who doesn't advocate including a prohibition broadly. In other words, if in California, you can drive and talk on the phone with a hands-free device. We're recommending that regardless of whether or not you have a hands-free device in the car, no business calls while you're driving. The distraction that results from employees on business calls can result in injuries, and those can lead to exposure to the company. Generally speaking, it's not a good idea. We recommend that you instruct employees to either pull over or continue the call after they get to their destination, and do the same if they suspect that the person they're talking to is also driving for work. It's just one of those things. I don't recommend allowing any sort of leeway here. With regard to search inspection, it's necessary. Employees can create a reasonable expectation of privacy if we don't take that reasonable expectation of privacy away with something like an employee handbook policy. You want to reserve the right, if necessary, to inspect their lockers or their desks for contraband if it's suspected that the individual has brought that on company property. So you need to broadly reserve the right to do so that they don't develop an expectation of privacy. That's certainly just something that we would see in every employee handbook. I've never seen an employee handbook without this language. Electronic media, same thing. We want to take away the reasonable expectation of privacy in anything stored or transmitted over the company's system, the company's intranet. You want to reserve and monitor, reserve the right to monitor and retrieve, for that matter. And of course, electronic media policies can implicate Section 7 rights under the National Labor Relations Act and should be reviewed by your legal counsel. This is one of those areas where I would flag that for special attention for your legal counsel. Same thing with social media. This is probably the hottest area that we're seeing in regards to employee handbooks. This is actually one of those areas where, if employees wish to talk about work on, say, a social media site, they probably already have friends that they've connected with. So making a post or sharing a post regarding a concern that they had at work, because they're sharing that with coworkers who they're also friends with on social media, can trigger those Section 7 protections that we were talking about earlier, which means you have to be very careful about how that's posted. We're seeing a lot of involvement, or a lot of developments in this area. This is just simply something, as a general rule, I would not draft without consulting employment law counsel, since the National Labor Relations Board has been in the past very particular about what it wants on your social media policy. Acknowledgements of receipt, this is just critical. The concern, of course, in any employee handbook is the employee being able to argue, well, no, I never read it, or it was, I didn't know about policies X, Y, and Z. So you want acknowledgement of receipt page to reflect that the employee is being held responsible for having read it and is aware of it. You can also consider additional acknowledgements in addition to the general acknowledgement of receipt of having read the entire employee handbook, specific policies that the employee signed off regarding the harassment policy, the interactive process or reasonable accommodation policy, meal and rest periods for non-exempt employees and salary basis for exempt employees. We're seeing a trend where that's being done as well. When it comes to kind of providing a big picture summary here, never implement policies you're not willing to commit to in every case for every employee. You and your counsel will also want to decide how best to preserve your at-will language via your employee handbook. There are different strategies I've seen employed by employers over the years. You and your counsel want to be on the same page regarding how that'll be done, and always have legal counsel review essential documents that you publish to your employees so that there aren't contradictory statements that can compromise at will. And then when it comes to updating your employee handbook, you want to do that as laws change, and never less than every 2 years, even if the law is stagnant for whatever reason. Certainly in California, that's very rare. But even with that being the case, even if you're just changing the publication date, so that if a plaintiff's attorney looks at that employee handbook and sees that it was drafted within the last 2 years, they're aware that you are up to speed and generally responsible about updating your policies and procedures. With that, I will hand it over to Bill for some additional comments about developing your handbook.
Thanks, Mark. Obviously we're seeing that there's so much that has to be considered in addressing your handbook. Whether you're just looking at it to review it, whether you're trying to update it, whether you're trying to develop a new handbook, the search for the perfect handbook will go on. It's not going to be settled through this program, nor will I'm willing to guess that none of us participating in the program today will ever find that formula. And if we can, more power to us. I'd love to talk to the person who does. But let's talk about a few things that we see here when it comes to developing a handbook. Number one, you've got a handbook. Now you're looking at it. You've got to decide: does this need to be updated? Do I need to do a serious revision of it, or should I burn it, pretend it never existed, and start from scratch? Interestingly enough, the most difficult thing to do is to revise a handbook. When you try to revise a handbook, you've got to go through every single word of that document. It probably means it's been a couple years since it's last been worked with, but it's not just a matter of inserting a new policy in. Oh, EEO has changed, let's get ourselves a new EEO policy. Oh, this social media idea, let's just insert a social media policy, because every policy connects to other policies. So it's going to be really, really critical if you're sitting down to update your handbook that you're prepared to really go through every single word there. When we talk about revising a handbook, or updating a handbook rather, we're talking really about, gee, it's been a year. We now realize, oh my goodness, we don't have gender expression in our EEO policy. Let's add gender expression. All right, maybe that's all we need to do. If you're on top of your handbook, you can probably get by with something like that. But if it's been a couple years, you've got to look at doing a serious revision or starting from scratch. When it comes time to do this work, who should do the work? Should the HR department itself do this? Should you call an attorney and have them do it? Should you bring in an outside consultant? Should you identify a template to work with? All of these are reasonable approaches to working with your handbook. They have their strengths, they have their weaknesses. Attorneys, obviously it can be a little costly sometimes. You also might wind up with a document that is not completely in touch with your actual workforce. Maybe not. That's not to say that attorneys don't do a great job on handbooks. We see a lot of handbooks drafted by attorneys that are really, really good. But keep that in mind in terms of the costs and just to what extent it's going to actually speak to your employees and how important that is. Does the HR department want to do it? Yes, great idea. I can't tell you how many calls we get from HR departments saying, hey, we've been working on our handbook for 2 years now. We're nowhere near getting it done. Can you help us? It's a really, really tough thing. It's not as simple as it sounds. And when the CEO somebody says, hey, can you update our handbook? They think it might be really easy, but we all know it's not. There's a lot to it. Bring in an outside consultant, great. Don't expect it to get done in a couple of days or in a week. It is an engaged process. It does take time, and certainly something to consider. The idea of acquiring a template and looking at overall what are the best tools to work with. Yeah, this is always a really good idea. Remember that it's not as simple as the advertisements that you might see or what you hear as you're scrolling through marketing campaigns about these. It's not as simple as, you know, hey, I'm going to sit down and answer a couple questions and print out a new employee handbook. There's a lot that goes into it when you're working with a template. And there are some really good ones too. Be careful when you go to your payroll provider, for example. Payroll providers have some really good templates for handbooks, and they'll do them for you. They tend to be based on the perspective of your payroll firm. Just keep that in mind. Same thing with attorneys who are going to be very legalistic with it. So keep in mind what your philosophy is going to be in terms of how your handbook is going to address all your issues and how it's going to speak to your employee population. We are not, and also, oh, by the way, keep in mind when you're working with a template, you have to really have answers to all these questions before you sit down to work on that template. There's a lot of stuff that you need to know, and every time you say, you know what, I'm going to make a change here, I'm going to change this part here, I'm going to change that part there, you're creating a new liability. So if you're going to commit to working with a template, commit full on to using what's in there, because these are usually very carefully drafted and very cohesive documents. So every time you make a change to it, you're opening up a potential liability. We do not recommend acquiring a bunch of different samples from different resources. We love the internet, everybody does, but it's not the best place to go on to try to build your handbook through different samples. You really want to be specific to your organization, to where your employees are located, know what's going on in each city, each state, as you do that. And the bottom line on this, go back to that concept, the Mr. Potato Head concern that we have. Use a single resource. Have somebody be the driving force on this, and they're going to make the final decisions, and it's going to be them. I'm going to deny that I said this, but try to keep your CEO, your CFO, your controller, to whatever extent, only an advisory role, not driving this process, only because it's a document for your employees. And that message, while you want that message at the beginning from your president, from your CEO, the rest should be pure and not impacted by too much by what the head of the company wants to do, but really what we know needs to be done for compliance and for the better purposes of our employees. So again, bottom line, use a single resource to do this that's going to really drive the process. And here's really critical thing. Mark has touched on some great details on some of these policies, but just from what we've gone over here, we know that, man, there's a lot of detail that goes into these handbooks. There really is. And the bottom line is, we go through all this trouble to create this document. Now we want everybody to understand it. Nobody's going to celebrate you for doing it, but we want them to read it, to understand it, and to follow it, because you're going to be so much stronger as an organization when you do it. So when you get your handbook updated, or you have your new employee handbook, train. Always train on that handbook. Get every single employee in your organization involved in training. Set a series of meetings. They probably don't need to be more than 30 minutes, lunch and learns, whatever it might be. Anybody that's not right there, set up, make sure they join a webinar on it. Distribute the handbook about a week to maybe 10 days or so before your training session, so that everybody has a chance to read through it. Ask them, please read through this prior to this. At the training session, you're going to walk them through the key policies. In particular, you're going to walk them through the policies for which you have acknowledgments. And I'll go back to what Mark has talked about here too. There's the 5 acknowledgments on the handbook itself, and at will, and meal and rest period for your non-exempt, salary basis for your exempts, that interactive process, reasonable accommodation policy. So these are really critical if you want to have your drug and alcohol policy, your searches. There might be 1 or 2 others that you want an acknowledgement on, but really make sure everybody understands these. Leave plenty of time for questions and answers, and at the end of your training session, you'll provide the acknowledgments, every acknowledgement that you want signed, and make sure everybody understands it. And in the acknowledgement, it should say, I acknowledge that I have read and I understand the XYZ Corporation policy on harassment, on meal and rest periods. whatever it might be. They sign it, they date it, and it goes in their employee file, and you will be in a much stronger position should there be an issue that comes up later. One thing that we do get questions on quite a bit is, do we need to translate our handbook? Great idea. We love the concept. It can be very costly to do, but certainly something we want to encourage whenever possible, but at least consider strongly translating your key policies. Remember that in California since April of 2016, we requirement that there are many situations under which you will need to translate your harassment policy and get that signed off on by all employees. So it's something we always want you to consider, at least with the key policies. This completes the information that we wanted to get out to you today, and we've managed to through speaking quickly, we've managed to get through the key information we've wanted to get through. Finally, I want to make sure that you are familiar with and able to reach out to our handbook team here. I am not the specialist on this, but I am the point person for it. So usually the initial inquiries come to me, and then I will distribute that out to the real specialist. So thank you very much for participating in our program today. We really appreciate you taking the time out of your morning to do this with us. Stay tuned. We'll have an announcement out shortly regarding our July program. This is our Webinar Wednesday sessions. We do these every month. They are a member service, and we invite everybody to participate in them, and it's something we always look forward to doing.